All right, this is case number 20 CR 269, State of Ohio versus Brittany Kessler. Are you Brittany Kessler? All right, now Ms. Kessler, you were put on intervention in lieu of conviction back on March 8th, 2021, and there was a notification filed and a motion to terminate that on February 9th on the basis that you have failed to comply with Rule 14 that requires you to make payments on the account for the court, which would be a court cost, and have a balance of $170. And then there's a $290 for programming surcharges that's owed to the department. And so that'd be a violation of Rule 14 or Rule 23. Now, you have a right to have a hearing on this matter and to have an attorney to represent you. And if you can't afford to hire an attorney, the court will appoint one for you. The hearing would require a presentation of evidence to prove that this has occurred. And in the event that it has occurred, I could terminate you from the program and find you guilty and then have a sentencing hearing, or I could extend it for up to 5 years, because that's the maximum period of time you can be on the program, to give you the opportunity to make those payments. You have a right to present evidence on your own behalf and to subpoena witnesses to testify for you, just like the state could against you. And you have a reasonable period of time to have to prepare for hearing, and that would probably be on March the 6th or 7th. Was probably when the hearing would be, because we'd have to have it done on or before the 8th, and the 8th is fairly busy. Now, you understand the allegations?
Yes, sir.
Okay. And do you wish to have an attorney to represent you in this matter?
Yes, sir.
All right. You understand that if you cannot afford to have an attorney, the court will appoint one for you?
Yes, sir.
And that would be at no cost. Okay. And you understand that if you don't have counsel, then you will have to make your own decisions. You feel you can do that, okay?
Yes.
And has anyone promised you anything or threatened you in any way to get you to admit to the violation?
No.
All right. Well, if that is your decision, then I need you to sign a waiver of counsel form. I'm going to fill this in. What this is for is to put in a file to show that when you were here that you did have the opportunity and were aware of your right to have an attorney to be appointed to represent you, and you chose not to do that. And so this form has your case number and your name, and it says, I, Brittany Kessler, defendant here and being now in open court, fully understand under the laws of the state I have a right to legal representation, do hereby affirmatively waive my right to be represented by counsel. So that's just showing that you're giving up your right. Is that what you want to do? Okay. Would you go ahead and have the bailiff show that to you? If that's what you want to do, sign it. If you decide to change your mind, that's fine too. Is this your signature on the waiver of counsel form?
Yes, sir.
You understand by signing this, this is a documentation that you've given up your right to have an attorney to represent you at no cost in this proceeding. All right. All right, then, Ms. Kessler, do you admit or deny the allegations in the notice?
I admit it, sir.
Okay. All right, as I assume then, based on the file, Mr. Orzima, that she has complied with all the other requirements?
Yes, sir.
Okay.
It's completed treatment, report,
Okay.
status.
All right. Are you working, Ms. Kessler?
Not yet. No.
Okay.
I did make a $50 payment 2 weeks ago. I'm just waiting for my mom to get her check in first, and she
Okay? What I'm going to do is I'm going to extend the period for 1 year. But if you do get everything paid off, then Mr. Arjima is satisfied that you're still compliant. He can file a notice of that with the court, and then we will terminate the, and dismiss the case. So that's the only thing that's standing between you and being off paper. And so there'll be a few more dollars added to court costs because of today. But if you get those, as soon as you get those paid off, and as long as you continue to, comply as you have, there's no reason why this can't be paid off, dismissed. Then I will tell you this as well, that if you want to have what I do, and when I do dismiss these, then I set the matter for a hearing to seal the record. It'll show in the files that it's been dismissed, so you don't have a felony conviction. But if you want to get that sealed, there's an additional $50 charge. I'll go ahead and set a hearing for that, and I'll order that after the hearing, and you won't have to attend that unless the state were object. And the only way that would happen is if something happened between now and then that would cause them to feel it shouldn't be sealed. So that'll be an extra $50 for that. So you might want to keep that in mind, that because then that way it'll be sealed, and all the records of it at all the law enforcement agencies and the court and on the computers and stuff will be removed and will be in the record. And then you can answer, and you still can say that I don't have a felony conviction, but if they do a background check on you, until that's sealed, it'll show up. All right, so you've done very well. We don't want to see this stand in the way of getting this off of your record. Okay?
Thank you.
All right, thank you. Okay. Now, is this All right, are you Marshall Kane Smith on appearing on the screen? It says Kane's A53.
Yes.
All right. This is case number 22 CR 244, State of Ohio versus Marshall Kane Smith. Mr. Smith is appearing by Zoom from his, looks like his home. Appearing on behalf of the defendant is his attorney, Dennis Kirk, from his office. Appearing from the prosecutor's office is Mr. King, assistant prosecutor. Defendant is charged with aggravated possession of methamphetamine, a fifth-degree felony. This matter was set today for a plea hearing, and I've been presented with a plea of guilty form, Mr. Smith, which indicates you're going to plead guilty to the charge in the indictment. I'm going to hold up the first page of this document so you can see what I'm looking at and make sure that is the document you're familiar with.
Yes, sir.
All right. This is a 3-page document, and on page 3, about a third of the way down, there's a sentence that reads, "I enter this plea voluntarily," and immediately below that there appears the signature Marshall Smith. I'll hold that up to the camera and ask you if that is your signature there that I'm looking at.
Yes, sir.
And when did you sign this document, Mr. Smith?
A couple days ago in my attorney's office.
When you signed it, did you understand that it was an agreement to plead guilty, which means there won't be a trial, and the next step in your case will be a sentencing hearing?
Yes, sir.
And did he go over it with you and let you read it and explain everything to you and answer any questions before you signed it?
Yes, sir.
And did you enter into this agreement to plead guilty voluntarily?
Yes, sir.
Yeah, you were not pressured or rushed in any way into doing this.
No.
And you still wish to go forward with the agreement and plead guilty today?
Yes, sir.
All right, now the agreement states on page 1 that you're going to plead guilty to the charge of aggravated possession of methamphetamine, a fifth-degree felony, under section 2925.11 of the Ohio Revised Code, a fifth-degree felony. It further states that you understand that the maximum penalty of that could be 12 months in prison. The minimum would be 6 months if prison terms imposed. There could be a fine of $2,500. There could also be a license suspension of 6 months to 5 years. Do you understand that?
Yes, sir.
All right, now are you facing any felony charges in any other jurisdiction?
No.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, sir.
Right now, under the law, Mr. Smith, the maximum penalty for this, as I indicated, as far as prison time is concerned, is 12 months and minimum of 6. Should there be a prison term imposed and you serve that term, once you complete it, the law provides that as part of the sentence, the adult parole authority could decide to put you under post-release control supervision for a period of up to 2 years. That means you'd be supervised under the terms they set, because the court's not involved with that, by a parole officer. And if during that period of time they determined that you had not complied, then the adult parole authority could return you to prison to make you serve an additional period, even though you served the entire term set by the court, of up to, in this case, 1/2 of your prison term for one or more violations. But if you commit a new felony, then in addition to whatever sentence a judge in the new case could impose upon you, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
Now, under the law, I'm not required to sentence you to prison for this offense. I can impose what's called community control, which is what most people understand to be probation. That means you'd be supervised by a probation officer under the term set by the court for a period of up to 5 years. If during that period of time the probation department thought that you were not compliant, they would file a written notification of that with the court. You would get a copy of that. There would be a hearing. You'd be entitled to be represented by an attorney at that hearing. If the outcome of that hearing was that you had failed to comply, then at that time the court could revoke your community control and then sentence you to 12 months in prison and fine you $2,500. Do you understand that?
Yes, sir.
All right, now the charge in this case alleges that on or about March 31, 2022, in Highland County, Ohio, you and a Sylvia Marie Cutler did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine. So that's the violation of 2925.11 of the Ohio Revised Code, the fifth-degree felony, with the penalties I've described. Now, you understand what it is you've been charged with by the state, what they said you did, when, where, and how they led you did it.
Yes, sir.
And you understand the possible penalties for that offense if convicted.
Yes, sir.
Have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
And are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you taking, are you under the influence, I should say, of any drugs or alcohol at this time?
No, sir.
Do you take any prescription drugs?
No.
Has anyone threatened you to make you plead guilty here today?
No, sir.
Now, there are 3 sentences on page 2 that are printed in bold and underlined that read as follows. Defendant shall under plea of guilty to the indictment, state and defense jointly recommend community control and substance abuse treatment. Defendant agrees to cooperate fully in the prosecution of the co-defendant. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, the matter of sentencing is not up to the parties. The judge is the one who makes that decision. And so even though there's an agreement between the parties, the judge under the law does not have to follow that. And so if I would decide after I've heard all the information presented at the sentencing that that was not the correct sentence, you could end up being sentenced to prison for between 6 and 12 months. You could get a fine of up to $2,500, and you could get a license suspension of 6 months to 5 years, or any combination of those. Do you understand that?
Yes, sir.
And I neglected to do this at the beginning of the hearing, but Mr. Kirk, you and your client are both in agreement that he appears remotely by Zoom rather than an in-person appearance in the courtroom?
Yes. Excuse me. Yes, Your Honor.
And you're in agreement with that, Mr. Smith?
Yes, sir.
Okay. If you need to talk to Mr. Kirk during this hearing, since you're not seated next to him in the courtroom, just tell me and I can put the 2 of you into a breakout room where you'll be the only 2 on the screen that can be in communication with each other, and no one else will be able to hear you or see you, okay? All right, thank you. Now, do you hold any license or certificate from any state governmental agency that regulates any trade, occupation, or profession?
No, sir.
Okay, now you have certain constitutional rights you must understand before I can accept the plea of guilty from you, Mr. Smith. First, you have a right to have an attorney. Mr. Kirk's been appointed to represent you, not simply to work the case out, but to provide any defense that could be available to you under the law that you would like him to provide. So, if you decide you do not want to plead guilty here today, he'll continue to represent you and defend you, including a trial, if that's what you want. Do you understand that?
Yes, sir.
All right, now under the Constitution, you have a right to have a jury trial on these charges, which means that 12 people would be selected from a group of citizens that reside in Highland County that are summoned for jury duty on your trial date. After those 12 are selected, the evidence would be presented and they'd be instructed on the law. And then that jury of 12 persons would have to decide by unanimous verdict, meaning they would all have to agree on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you did want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial, and in that case you would have what's called a court or bench trial, which means the judge would be the one who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
All right, now under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney in open court. What that means is witnesses against you have to come into the courtroom and testify in front of you and your attorney and anyone else that may be present. After the prosecutor's done asking those witnesses questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that would help your side of the case. Do you understand that?
Yes, sir.
All right, now under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order that's called a subpoena. And that forces those witnesses to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, sir.
Right now, under the Constitution, Mr. Smith, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this case at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. You make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. And in fact, no one is ever allowed to comment about it except in one situation, which is if there's a jury trial and you don't testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Right now, Mr. Smith, under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. What that means is that the burden of proof isn't on you to try to show you're not guilty. The burden of proof's on the state to prove that you are guilty. In fact, at trial, you don't even have to present any evidence in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain on the state of Ohio to prove your guilt on every essential element of the offense charged by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Right now, originally you entered a plea of not guilty, Mr. Smith. That plea denied the allegations in the indictment, denied you committed any crime, and it exercised or invoked all of the rights that I have just described for you. Now, if you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, that you committed that crime. And that plea waives, gives up all the rights I've described for you this afternoon, except the right to have an attorney. You always have a right to have an attorney, no matter what your plea is. But with that exception, your plea of guilty waives, gives up your right to a jury or court trial. It waives, gives up your right to confront witnesses against you and cross-examine them through your attorney. It waives, gives up your right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. It waives, gives up your privilege against self-incrimination because you're saying you're guilty. That's what's used to find you guilty. The waives, gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court, and it waives, gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if you are sentenced to the maximum sentence or under other limited circumstances, an appeal could be filed. That appeal would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen, Mr. Smith?
Yes.
Now, do you have any questions about the charge or the possible penalties?
No.
You understand?
Yes.
Have any questions about the plea agreement?
No.
You understand it?
Yes.
Have any questions about the constitutional rights I've explained?
No, sir.
You understand it? Then,
Yes.
you have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
You understand?
Yes.
Now, is there anything you need to speak to Mr. Kirk about before we go any further?
No, sir.
Do you have any questions about anything I've explained here today?
No.
Then is it your decision, Mr. Smith, to go ahead and plead guilty in accordance with the terms of this plea agreement that we've just gone over?
Yes, sir.
Then, as to the charge which alleges that on or about May 31, 2022 in Highland County, Ohio, you and Sylvia Marie Cutler did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, in violation of Section 2925.11 of the Ohio Revised Code, a fifth-degree felony carrying possible prison term between 6 and 12 months, possible fine of up to $2,500, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right. The court finds on this day in open court, the defendant was advised of all his constitutional rights, made a knowing, intelligent, and voluntary waiver of the same, pursuant to Criminal Rule 11. Please accept an order filed. Defendant is found guilty of the charge. Court will order the matter referred to the probation department for a pre-sentence report. Bond will be continued, and the sentencing hearing will be March the 29th at 9 a.m. Mr. Arjima, you want him to call you to make an appointment for the pre-sentence interview?
Can you be here tomorrow so you can get the packet? All right. Then we'll schedule it.
All right, go ahead and then report tomorrow to probation to get your packet and then make the appointment. All right, anything further from the council?
Yeah, Your Honor.
All right, then it'll be March the 29th, and we can probably do that by Zoom as well, as long as everything goes, as long as you cooperate and do everything you're supposed to do, we should be able to do that by Zoom. Unless we decide to go in person, I don't know what we'll be doing then. It's kind of going back and forth there with COVID and everything. So,
Right.
all right, thank you.